Tom, talking about things like body cam video and other new issues, are there, I mean, where does that issue, for example, stand now in Georgia? And what other issues are you looking at in terms of unclear legal questions or bills before the legislature?
Sure. So I think there's really four areas right now where I feel like over the last few years we've lost some ground in terms of access to records or access to information. Certainly one of them is police body camera video. Over the last few sessions, stretching back to the 2015 session, there's been two bills that have passed in an effort to clarify the public's right of access to police body cam video. Unfortunately, neither of those has succeeded in making the issue clear to law enforcement agencies. Even Georgia law enforcement agencies have an enormous level of variation on how they handle police body camera video, from simply essentially refusing to provide it to the public to some police agencies trying to be more affirmative in giving public access to it. But legislation passed in 2002 different bills in the 2015 and 2016 sessions. The general tenor of those bills was that when police are in a private environment, when their police body camera is operating inside a home or in other private environment, there will be limitations on access to that video. But when they're in a public setting, that should be available to the public. Unfortunately, as a practical matter, that has not clarified issues. There remains a great deal of confusion over how the investigative exception in the Open Records Act applies to body camera video. And so, as a practical matter, the public access in Georgia is very uneven. Other areas where there's big issues at the moment. A huge one is simply the investigative records exception. When the Open Records Act got rewritten under Attorney General Olens, Attorney General Olens included language that very forcefully said an agency that is under investigation for wrongdoing cannot invoke the investigative exception itself to conceal records. That investigative exception is supposed to be there for law enforcement, to allow law enforcement to protect their records. That clarification was needed because City of Atlanta Public Schools had themselves resisted providing records about the grading scandal that had taken place inside that school system by trying to invoke that exception. And so that had been very clear in the law. Unfortunately, in a decision from the Georgia Court of Appeals in the last couple years, the Court of Appeals essentially interpreted that to mean that clarification only applies when the agency is under investigation. If an individual within the agency is under investigation, an agency can still invoke the investigative exception. Let me explain what that means as a practical matter. Chatham County Sheriff's Office, Sheriff's Department, had an individual who was badly beaten inside the Chatham County Detention Center. A television station from Media General at the time asked for access to the video of that that demonstrated the individual had been beaten. The Chatham County Sheriff's Department said, no, we're not going to give you that. It's under investigation. And so essentially the fact that somebody had been beaten inside the detention center remained outside the reach of the media. And the media understandably said, look, you're the agency under investigation. You can't invoke that exception. If GBI invokes it, that might be something different, but you're the agency under investigation. The Court of Appeals unfortunately backed up the Chatham County Sheriff's Department and said they can invoke that exception because it's not the agency that's under investigation, it's an individual sheriff's department employees who's under investigation. That, it's always individuals that are under investigation. Individuals are the people who face the consequences. And so it essentially eviscerated the language that Attorney General Olins had inserted. So hopefully in a future year that will get corrected. I'm going to briefly touch on two other issues that remain a big problem. Just very recently, the Georgia Supreme Court concluded that court reporter recordings of the courtroom proceedings are not subject to not subject to government access to court records because they don't actually get filed in the court file with the case. That's very unfortunate, particularly unfortunate to the emerging media of podcasts, which frequently needs access to that audio in order to make effective podcasts about past court proceedings. Another issue that's been unfortunate is in a recent Court of Appeals case, there was an interpretation again of the Open Records Act that said the fines that the new Open Records Act applies if people do not if people do not comply with the Open Records Act will not apply to agencies. They will only apply to individual persons. I do not think that was ever the intent of the way it was written. The fines are intended to apply to the agency. If it's really going to be imposed on individual persons, they're going to be used much less frequently. And so there's issues that over the last few years have created holes in what we thought was the tapestry that protects access to government records. And so my hope is that over the next few years in the Georgia General Assembly, we can tackle some of those and correct them and make these records accessible to the public again.